Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Today I'm coming to you from Sanibel Island, Florida. I'm on vacation and I want to tell you this quick story. I had a case where I represented a woman. She underwent a medical procedure, and as a result of improper treatment, she suffered a significant injury. Now, her name doesn't matter, the exact procedure doesn't matter, and the exact amount of money I was able to recover for her doesn't really matter for the purposes of the story. The story is about the doctor who refused to consent to settle. Now, what does that mean? It means that the doctor at the beginning, before we had an opportunity to start the trial, had a chance to try and negotiate this case to try and settle before we actually went to a trial and to a verdict. The doctor refused to settle the case. Now, in New York, there are some insurance companies who represent doctors who give the doctor the opportunity to either consent to settle or not. If the doctor has that type of policy and he refuses, what happens then is that his defense lawyer and I now have to go ahead and try the case. And that's exactly what happened here. But here's the ironic thing. We had the opportunity to settle this case during jury selection for $125,000. In fact, the defense attorney and I had a great conversation where he basically told me, he said, listen, this is a fair number, this is an appropriate number, and if I had the authority and the ability, we would settle this case for $125,000. The reality was the doctor turned around and said, no, I'm not settling this case under any circumstance. Well, that basically forced our hand, forced us to go to trial, and as a result of 2 weeks of hard-fought litigation, bringing in experts and testimony, and bringing in everybody and showing the court evidence and showing the jury all the evidence necessary, at the end of the case, the jury wound up awarding my client a 7-figure verdict, which is more than $1 million. And again, the exact amount is not important for the purposes of the story. What's amazing is that after the trial was over, the defense then went ahead and started to try and whittle down that number by going ahead with paperwork known as post-trial motions. And then they were about ready to file an appeal, at which time we were able to settle the case for a very high 6-figure number, which was significantly more than what we were willing to settle the case for at the very beginning. The reason I tell you about this is because there are many times where the defense will have an opportunity to try and negotiate and settle the case. And if the doctor turns around and says, listen, I'm not settling this case and I have a consent policy which gives me the ability to either agree to negotiate or not, and I choose not to, well then you're going to wind up going to trial. Chances are you're watching this because you have questions and concerns about your own particular matter. And if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is what I do every single day. I answer legal questions just like yours. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in Sanibel Island, Florida. Have a great day.